Hey, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Stephen Marso, an Iowa construction lien law expert. Today's webinar topic is indemnity in Iowa, one contract term you don't want to miss. So without further ado, I'd like to introduce Stephen Marso.
Thanks, Jesse. Hi, everyone. My name is Steve Marso. I'm an attorney with the firm Whitfield Eddy in Des Moines, Iowa, and I'm going to talk about indemnity in Iowa with the focus on construction, the construction context. I'm licensed in Iowa, so that's going to be the focus of my presentation here. And as Jesse mentioned, it's indemnity. It's an important issue. There's a lot more to indemnity than what we're going to cover today, but hopefully today we'll give you some information that maybe you didn't know before. And one of the important takeaways is, especially if you're a contractor or someone dealing with this in a construction contract context, is to be in regular communication with your insurance agent to make sure you have the necessary coverage to protect you in case you do have some indemnity obligation. So that's one main takeaway here. Before we get into the substance of this, here's some directions on posing questions. So you can ask questions through the webinar chat box as noted here. And then at the end of my presentation, Jesse will let me know if there's any questions and I'll answer those. So feel free to ask questions. Okay, let's get started. So the first question is, what is indemnity? It's a word that I think people hear frequently in the construction context, but it's often misunderstood. So here's a definition from an Iowa Supreme Court case. And what indemnity does is it shifts the entire liability or blame from one party to another. That is in contrast to another concept called contribution, which maybe you've heard. And contribution is a sharing of the blame or risk. And so that often arises in what's called the tort context. So example, an auto accident. There can be contribution claims among various parties who might have contributed to the accident and might share blame. That's called contribution. Indemnity, though, is different. It's a shifting of the complete liability. And so that's important to remember, because if you have an indemnity obligation in your contract, that's going to shift the entire liability to you if you're obligated to do that. So that's the definition. That's what we're talking about today. And there's different types of indemnity. There's the contractual indemnity, which again, contractors, owners of projects, that's common. It's a common contractual term. But there's also implied indemnity obligations. And here's a discussion by the Iowa Supreme Court about a couple of different main areas of implied indemnity. You can have an implied obligation based on contract. So even if your contract does not have a standalone indemnity provision that explicitly requires indemnity, you can still have a contractual implied obligation to indemnify. And it kind of depends on what your obligations are under the contract. So that's one main area. The other one is outside of the contractual setting, and it's implied in law or equitable. So there might be situations, and we'll get into some of those, where even though there's not a contract between the parties, there might be an implied obligation to indemnify. And sometimes those terms are confused. So essentially you have the express contractual indemnity, which is the most common that we see. And then you also have the implied contractual indemnity, okay? So that's a little different. And then the implied equitable indemnity, which is outside the contract context. Okay, so in Iowa, the Iowa Supreme Court allows indemnity in 4 general scenarios. And one of those is express contract. And again, that's the most common that you're going to see in the construction context. The standard form contracts, AIA, the other ones have standard indemnity obligations, and they're essentially, they essentially exist in pretty much everything that I see. It would be the rare case where you don't have an indemnity provision construction contract. The second general area is vicarious liability. And what that means is a person who's vicariously liable is legally liable, but it's based on the actions of someone else. So, for example, in Iowa and many states, the owner of an automobile is liable for damages caused by a driver of that automobile if the driver was driving it with permission. So, for example, a parent who owns a car and their teenage son or daughter is driving that car and gets in an accident, the parent is vicariously liable under often these statutes that are called owner liability statutes. So that's an example of vicarious liability. So an owner could have an indemnity claim against the driver if the driver is the one that caused damages that caused the owner to get sued. The third one is the breach of an independent duty to the indemnity. And that's a general kind of broad term that this law review article I cite discusses in depth. I'm not going to get into any detail here, but it can be based on contract or tort law. The contract reference is kind of what I talked about earlier, the implied contractual indemnity. So even if you don't have an express indemnity provision, you could still have contractual based implied indemnity. So that's referring to. And the fourth main area is this primary versus secondary liability, active passive. That is essentially out in Iowa now, but it used to be a fourth area. And so there's a comparative fault statute in Iowa that essentially replaced that. So essentially in Iowa you have three main areas of indemnity. The fourth is no longer really valid. Okay, so indemnity agreements in a contract. So we're talking now about the express indemnity agreement in a contract. Okay, so that's what we're focusing on here. That can be broken down into three general categories: limited form, intermediate form, and broad form or fault-free. Okay, so those are the three main ones. Bruner and O'Connor, if anyone's familiar with that treatise, it's a really good in-depth one on many construction topics, including indemnity. Okay, limited form. So what is that? That requires the indemnitor. Okay, and let me back up. So an indemnitor is the person who has the indemnity obligation. The indemnity is the person who's receiving the indemnity from the other side. So, for example, if the driver of a vehicle gets into an accident, causes damage, and the owner of the vehicle gets sued and wants indemnity, the indemnitor is the driver, the one who caused the damage, who's providing the indemnity coverage or obligation. And so the driver is the indemnitor, the owner of the vehicle is the indemnity in that situation, okay? So a limited form requires the indemnitor to indemnify only for the indemnitor's fault or negligence, okay? And absent a contractual provision that says otherwise, that's generally the default rule. And that makes sense. You know, if you cause damage or you're at fault for something and it causes someone else to get sued for that, like the owner of the vehicle that I've given as an example, then the driver, for example, is going to have to indemnify for that fault, for their own fault. Okay, the next type is intermediate form indemnity. And that requires the indemnitor to indemnify not only for their own fault, but also for the indemnity's fault, okay? Now, it's not triggered if the indemnitor is fault-free, okay? So you have a construction project where a general contractor, one of their employees comes in and does something and solely causes some damage. The subcontractor, for example, is not going to have to indemnify for that because they weren't at fault at all. And so that's an intermediate. Now, if the subcontractor and the general contractor both were acting and both were arguably at fault for something, then this would be triggered, and the subcontractor under an intermediate form indemnity agreement would be required to indemnify the GC for their fault in that, and that's because the sub has some fault there. Now, in Iowa, there's a special rule that courts apply, and essentially it says it has to be clear and unambiguous in the contract that you have an intermediate form indemnity. So if there's ambiguity on whether or not that's the case, then they will not fine for intermediate form. They will fine only the limited form. Okay, so Iowa allows you to contract, at least under the case law that we're going to look at, and we're going to get into a statute that changes that. But at least outside of that statute, if you want to have this, you can draft it. You just got to make sure it's clear and unambiguous. The last form is broad form or fault free. So that example that I gave, where the GC comes in and is solely at fault for something and wants indemnity from the sub, and the sub has no fault, the sub would be required to indemnify the GC on this one, even though the sub has no fault. And again, that same special rule in Iowa applies, where you have to make that clear and unambiguous. Okay. So what I just talked about was the Iowa case law in interpreting these indemnity agreements. Iowa has passed what's known as an anti-indemnity statute. And there's various states that have these. I know Nebraska has this as well. I'm licensed in Nebraska as well, so I'm familiar with that. But Iowa has this, and it's in this Iowa Code Section 537A.5. And I'm going to go through that so you kind of have some takeaways here. So the first paragraph of the statute, that's what it reads here. And so the main takeaway from this paragraph is it only applies to construction contracts, okay? So it's not going to apply outside of the construction contract context. So the question is, what's a construction contract? And as you can see here, it's very broad. And so it's going to cover most construction contracts, almost all of them. One exception you'll note, it does not apply, if you look at the very end, to public agreements relating to highways, roads, and streets. So there's an exception for that, kind of what I call the Iowa Department of Transportation exception. And so on those kind of projects, then this statute does not apply. And then what you get is that case law that we discussed earlier, where there's rules about you got to make it clear and unambiguous. One question is, what's a public agreement? Is it only the agreement to which the public entity is a party, or does it apply to those subcontracts and purchase orders downstream between private parties on a public project? I don't know if there's been a case that's addressed that, but that's just an issue that I noted here. So anyway, that's kind of the general scope of what the statute covers. And then the second paragraph is the kind of the meat of the statute. What does it do? What it essentially does is makes intermediate form and broad form indemnity agreements void and unenforceable. Okay, so even if you drafted up a clear and unambiguous broad form indemnity or intermediate form indemnity agreement in your contract, if you're on a construction contract that's covered by the statute, then that's going to be void and unenforceable. It only allows limited form indemnity. So that's essentially what the statute does. So Iowa, Nebraska is another example. Those states that have this, they protect the parties essentially from entering into bad indemnity agreements essentially. Now there's some exceptions to the statute. So it doesn't apply to the indemnity obligations of a surety by a principal. So those before a surety typically is going to issue a bond, it's going to require an indemnity agreement with not only the construction company but often the construction company owners. So this statute does not apply to that. And then an insurer's obligation to its insured. So, an insurance policy has two main obligations. One is to provide a defense to a lawsuit. The other is to indemnify for any damage claims that the insured is against a judgment against. That's not affected here by the statute. And then a borrower's obligations to a lender, that's not affected. And then the strict liability law is not affected. Okay, so next category is the statute of repose for construction projects. And the reason I bring this up in the indemnity context is because this does affect, it can affect indemnity, because these claims typically personal injury, property damage claims that come in late years down the road on a project can cause people to seek indemnity. So you need to know that the statute of repose exists in Iowa, and it was passed in the last few years. And so it's at Iowa Code Section 614.1, and it's paragraph 11. So here's essentially what it does. If you have a claim that's based on the unsafe or defective condition of a project, so you build a project and someone gets injured down the road, or their property gets damaged for something, and they're going to sue for negligence or whatever they're going to sue for the damage to the persons or the property, there's a statute of repose. And there's three main sections of this. One is for projects for nuclear power plants, which typically you don't run into, but it's 15 years. For residential construction related projects, it's 10 years. And for any other improvements, so this would be commercial construction projects, it's 8 years. And the statute of repose is different than a statute of limitations, in that the statute of repose is triggered and starts to run even and is not told, or it's not delayed by a lack of knowledge of something. So for example, on a commercial construction project, if it's 10 years, 9 years, 10 years down the road, and nobody knew of this defect, and nobody could have known about it, it was a hidden latent defect, and it didn't arise until 10 years after the project's done, the statute of repose is going to eliminate that claim, even though nobody knew about it. In the statute of limitations context, those can be told or delayed based on the lack of knowledge. Okay, so the statute of repose is a big defense against these kind of claims once the period runs. Now, an exception is if there's any fraudulent concealment or intentional misconduct. So someone building the project does something defective and they knowingly do that and they hide it. And if that's revealed down the road, then you're going to get a 15-year statute of repose. So for example, commercial, it would turn it in from 8 years to 15 years. Now, another kind of exception is, let's say on a commercial project, you're at 7.5 years and you now discover this issue, this defective condition. That's going to get you an extra year. Okay, so it's got to be within that last year of the statute. And if you discover it, you get another year. So the 8 turns into 9 years in that situation. And then this just says that it doesn't bar an action against a person solely in their capacity as an owner, occupant, or operator of a property. So essentially, again, if someone gets injured on a project, so for example, say someone built a splash park and a child gets injured, they can sue the owner of the splash park, and the statute doesn't bar that, suing the owner, even though the owner might not know anything about it. Or if the operator of the splash park doesn't know anything about it, they can still be sued. And then, of course, what they're going to do is they're going to come in and claim indemnity or ask for indemnity from the contractor or whoever else was responsible for it. So that's where indemnity comes into this. Okay, the last category I want to discuss is attorney fees. And you know, when you get into a dispute and lawsuits, attorneys are involved and attorney fees get incurred, and people want to know, hey, can I recover my attorney fees or get those back from the other party? General rule in Iowa is, unless there's a statute or contract that provides for recovery of attorney fees, then neither party gets attorney fees from the other. And that's the general rule, and that's called the American rule. And that's generally the default rule in pretty much every state in the nation. So how does that impact indemnity? Well, let's say that a GC and a subcontractor have a written subcontract, and it has an indemnity provision in it. And it says, okay, sub, you have to indemnify the general contractor, including attorney fees, expert fees, and those kind of things. Well, what does that mean? Let's say that the GC and the sub get into a dispute with each other. Let's say a payment dispute, or some other dispute they have on the project that doesn't involve anybody else, it's just between them, that indemnity provision is not going to allow either of them to recover attorney fees. Why? An indemnity provision protects a party from a third party. So for example, that example I gave about the child getting harmed at a splash park, if the parents of that child sue the contractor and the contractor has to hire an attorney to defend against that, they can then go after the subcontractor, let's say, who caused the defective condition, and recover attorney fees because it's a third party suing the general for that. And the indemnity is going to cover that third party claim. However, if the claim is just between the general contractor and the sub who have the subcontract provision or the indemnity provision, then it doesn't apply, okay? So that's the important thing to remember is indemnity provision is not going to apply to a dispute between the parties to that contract that has an indemnity provision. Okay, so that's an important thing to remember, and the Iowa Supreme Court made that clear in this case. Okay, well, I think, let's check. Yep, I think we're at our 20-minute mark, so that's all I have, and I'll, I guess, go to Jesse and see if there's any questions.
Yeah, thanks so much, Steve. I appreciate all of that information. There are a couple of questions that came through. We'll start with this one first. It says, if you're fault-free and the GC is the one at fault, you have to have a broad form indemnity written into your contract to protect yourself beforehand. So it has to be in your original contract is, I guess, what they're asking.
Yes, I mean, technically, parties could agree after the fact to indemnify. I mean, there's nothing that says that you couldn't do that, but I think the odds of that ever happening is essentially nil. I would suspect no party is going to agree to indemnify someone who is 100% at fault after the fact. But so practically speaking, yes, you're going to have an agreement up front before the event occurs that then one of the parties can point to and say, hey, we agreed to this. Now this event occurred. You have to indemnify me. So the short answer to your question is yes, from a practical standpoint.
Okay, and then the other question that has come through, and I think your last slide actually just touched on this, it says, can you get out of the liability if you have indemnity in your contract and you're fault-free?
So if I'm a party who's being asked to indemnify someone, I'm fault-free, can I get out of liability? Assuming that agreement is enforceable, that does impose liability upon you. So, but here's how it works. So let's say that you're the subcontractor and you're fault-free, and the general contractor is saying, hey, you need to indemnify me, even though the GC I'm 100% at fault because we have this broad form of indemnity agreement. The GC is going to be probably being sued by someone, okay? And that's why they're asking the sub. So here's how it works. The general contractor can defend against that claim without the subcontractor. And then after that's done, they can come back and sue the subcontractor, recover, say there's damages they had to pay the other party that sued them, plus the attorney fees they spend in defending it, those kind of things. They can sue the sub for that after the fact to recover those damages. And that can be a liability to the sub. Or the GC could sue the sub in that same lawsuit they're being sued in and say, hey, I'm being sued here. I'm bringing you in because you're obligated to indemnify me. So that's how it would work. But indemnity technically is a reimbursement. Typically, now there can be language in it that says, no, you have to come in and you have to pay as we go. Okay, but insurance policies, and the reason I bring this up is insurance policies, I think, generally are reimbursement usually, which means you have to incur the expense and then you have to seek reimbursement. Indemnity agreements can be more precise and say, we're not going to just require reimbursement, but you have to pay as we go. So I want you in the case, you're paying the attorney as we go. If there's damages for the third party is getting, you have to actually pay those. I don't have to pay them and then get the money back from you. So it's a little more technical than maybe what the question is, but that's how it works. And then that gives rise to this issue I said, where you can sue the sub, for example, after the fact or in the same lawsuit.
Okay. All right. Well, thank you so much for clarifying some of that information. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions as they come in. Can you go to the next slide for us, please, Steve? Perfect. All right. So here are some of SunRay resources to help you guys stay organized, know your deadlines, and secure your lien rights. Please go ahead and scan that QR code to access these incredible resources. If you're working in a nearby state and you might not know those state laws, remember each state has their own unique lien laws and deadlines, document types. So please go ahead and check out our website. It will have all of that information for you. That way you guys can stay really organized and make sure you're not missing any deadlines. Can you go to the next slide for us, please? All right, so we have a new service at SunRay. If you want, give us a call. We'll help you with your collections potentially to help get you guys paid. So go ahead and give us a call for that. And then the next slide, please. All right, if you don't mind, take a moment to give us a review on Google. We'd really appreciate it. We love all your feedback so that way we can help and continue to improve our webinars and make sure that we're getting the correct type of content out to you. It takes about a minute of your time, so please, if you don't mind, give us a review and give us some of that feedback to help. All right, go ahead and to the next slide, please. All right, and with that, that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. Thank you again, Steve. You are incredible. I appreciate all your hard work and preparation for this and going over all the details with us. I hope you all have a wonderful and beautiful sunny day.